next matter to come before the court this morning is William J. Gallagher et al. Versus Debra A. Fast et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, if you would let me know when you get started, if you'd like to reserve any time for rebuttal. I'm keeping the clock. You can also reference it on the wall to your side over there. The arguments are being recorded and they will be placed on the court's YouTube channel. Please keep your voice up, introduce yourself, and remain behind the podium. You should not use the names of any children, minors, victims in your argument. It may not be relevant to this case, but because, as it just noted, that the arguments are being recorded, we like to make that advisement before the beginning of each oral argument. The judges have read your briefs. We're ready to see who you are. Would the appellant like to reserve any time for rebuttal?
I'd like to reserve 5 minutes, thank you.
Certainly, thank you.
And please record, I'm Darren Avery on behalf, along with Brian Halligan on behalf of William Gallagher. Now, I noticed something just yesterday, an omission or error in my merit brief. I did not, in the appendix, I had 3 copies of the judgment entry denying the J&OB instead of the judgment entry denying the JOB and the judgment entry from the jury trial. I brought copies of that if you would like those right now. They're in the record as well. But
If they're in the record, I think we're fine with that. Thank you, counsel, for noting it, however.
Thank you. Brief summary and kind of an overview of the facts to kind of make this whole thing make sense. I think it's important to notice or note initially, we have defendant Fast and Dagley in a romantic relationship living together for something like 5 years, 4 years before the judgment against Dagley and a debtor's exam that occurred, I believe, in September of 2015. So they know each other very well. Sorry. She is aware, and this is strictly from her testimony, she is aware, through this whole thing, that Dagley has no outside income. She is aware that he is, I'm going to say, purportedly poor or penurious. And she is, when she's in control of BDP, and again, her testimony, she did not give him a wage, she did not give him a W-2, she did not give him a 1099. Her primary defense, meanwhile, is only to constructive fraud, not to the actual fraudulent conveyance. And it revolves around this running tally that she comes up with partway through litigation. And she testified that these IOUs previously that he had paid back, she discarded. Okay, now, I cannot, in my mind, this is extremely important. She's aware that the money with which he's paying her back is her own money because she is the sole owner of this BDP, and he's paying her back for what are his living expenses, and not just his living expenses, but also some of her luxuries. For instance, let's say like a Jeep ragtop or something like that for her child, a car payment, things like this, trips to all over, $2,500 nights in Columbus, things like this. He's quote unquote paying her back from this revenue that belonged to her anyway. Okay, so at the outset, it's this big picture. The defense is completely fraudulent on its own, and it's still going forward now. And I'm dealing with the facts before I get to the legal question. At the beginning, we have these couple of checks that were from SLB clients to Dagley, signed over Fast, and then she changes the name of SLB to BDP. I mean, these are kind of like the red warning signal, the blaring red light. And then at the end, and then they're together for a couple of years, and then when they break up, 2017 or 18, the other kind of big signals are this tax return business that I believe in Fast marriage brief, she said Fast invested $44,000, repeated that number, $44,000 into BDP, as if she's doing it as a business investment. She's not treating this as a business investment. Clearest piece of evidence on that is that she released the mortgages for something like $176,000, another one for maybe another $60,000. She released those at a time when she was not aware the building was underwater. If this were a business investment and she claimed she was owed money, she would have foreclosed. that she released him to her, we're not really sure when exactly they broke up, but either lover or ex-lover. And, sorry, that tax payment or investment into BDP was not real. It was deposited in the BDP account, $44,000 was a federal. The state was something like 15, if I recall correctly. But in each of those cases, the next day, I'm going to say 35 or 34 was transferred to her own personal money market from the federal, and then I'm going to say 10, the day after the state return was deposited, was transferred again to her personal money market. This was not an investment in BDP. This was a way to, maybe after the fact, a way to deceive or something like that. Anyway, the point of all that is FAST is aware and has her eyes open as to what's going on. That makes her behavior, at least with reckless disregard for the rights of Gallagher, and possibly intentional, likely intentional in light of her benefit by virtue of all the tax deductions that she received. And she acknowledged those in her own testimony. All right, then back to the actual legal assignments. I mean, the biggest one we have, or right in my mind, is the jury instruction errors. We asked, first off, we had no discussion in the courtroom about the jury instructions. We presented ours timely. That's not on the record, but we put it in our J&OB affidavits, and the judge instructed us or suggested to us that we file a post-trial motion after, well, it's in the affidavits, but it went something like this. The jury has a question. Everybody agrees on that answer. That's the first one. I think that's on the record. The second time the jury has a couple of questions, we don't agree. FAST says yes, we say no, but nobody has any authority. It's after hours. We can't go find something in the library. I had a stack of Oger photocopies, and I immediately start digging through those. As soon as the judge leaves the room saying he's going to say yes to the question, you find the authority saying the answer is no, approach him. Again, this is in the affidavits, all three, in the J&OB filing.
Other than your affidavits,
Yes, sir.
is that on the record, the transcript somewhere where the court reporter called in where the judge said, here's the question?
It was not, but the affidavits were unchallenged. Everybody was in the room. They could have challenged it then. Approached the judge and he said something like, I already instructed him. And then it's clear, I think what is clear in the record is after the jury comes back in, I'm attempting to put on the record a proffer, and he shuts me down. I mean, he literally yelled at me. So that's clear in the record. But he said, file them, or I said, you can file a motion, is what he said. So we did. Anyway, that was for that jury instruction. But sorry, I completely lost my train of thought because I'm going all over the place. But prior to that, when we were talking about jury instructions with the judge or with the other side, we were ordered in advance by email to submit them. We did that. That is also in the affidavits, and we submitted our copy of what we submitted.
When you take order, was it a written order, issued by the court, it's oral statement from the judge, do this, do that?
It was an email from the judge's administrator to all the parties. And I believe I attached that to one of the affidavits. All right. In any event, we did that. There was no discussion then. He just said, I'm adopting the other sides. I objected, and I cited in the brief where I objected multiple times. He gave us different instructions as to when we should object and discuss our objection or specific objections to those instructions. But we made multiple attempts. They're clearly in the record. All right. Specifically, we wanted the judge to instruct the jury on the statutory badges of fraud, because the defense was only around constructive fraud, it was not around actual fraud. And the jury actually found a fraudulent conveyance, but it would have saved a lot of time in oral argument, or I'm sorry, in closing argument, to not have to go through those things. And as I said in the brief, carries a lot more weight when it comes from the judge. That's one. Two, we wanted joint civil liability. I cited authority for why we should be entitled to that, and also punitive damages instruction. Also cited authority as to that. And it did not need, and again I cited authority, it did not need an additional showing of malice above that involved in the fraudulent transfer or in the conspiracy, which arguably, excuse me, back to the conspiracy, that is arguably the most important of the mistakes, because the intra-corporate conspiracy doctrine, as I stated in the brief, indicates or says that the judge's instruction to the second jury question was incorrect. He said, yes, Dagley as agent of BDP could conspire with BDP, and that's not correct. At the time, Fast was the only member. There was a conspiracy. The jury found there was a conspiracy. It had to be between two persons. Dagley's obviously one of them. He's the one they found liable for fraudulent conveyance. Who's the transferee? The transferor is Dagley, at least with respect to the initial checks. The transferee is obviously Fast. It's the only other person in the game. Can't be BDP according to the inter-corporate conspiracy doctrine.
And counsel, you're just now reaching into that 5 minutes. You can reserve or proceed as you see fit.
This is, so I've used 10?
You've used 10.
Okay, yeah, I'll reserve. Thank you.
Good morning, Your Honors. Anthony Stringer on behalf of the App.No, Dr. Debra Fast, may it please the court. Last October 2022, something extraordinarily rare happened in the Ohio court system. A civil case went to a jury trial. This case was tried to a Wayne County jury in October of 2022. Back in 2019, the Ohio Supreme Court issued a summary on the Ohio court's statistical numbers. In that summary, it showed that less than 1% of civil cases in Ohio go to a jury trial. So this case fell in the category of the less than 1% of cases that actually saw the inside of a courtroom and was tried to a jury by a verdict. The appellant and his attorneys got their day in court and their opportunity to present their case to a jury. It was a 2-day jury trial. At the end of 2 days, the jury deliberated. They came back. They entered a verdict in favor of my client, Dr. Debra Fast, and all claims that were served against her.
Counsel, were there summary judgment motions filed in this case?
There was, Your Honor. So during the course of the litigation, we filed a summary judgment motion on behalf of Dr. Debra Fast. The basis for the motion is that this is a fraudulent conveyance case. So it's kind of, you got to follow the money. And what we established in summary judgment was that the undisputed evidence showed that Dr. Fast paid out much more money to both Mr. Dagley and the business BDP than she ever received in return. So based on that undisputed evidence, plaintiffs could not establish prima facie case for fraudulent conveyance. So we did file that motion. It was denied. So the case proceeded to trial. At the end of trial, again, the jury came back, found in favor of Dr. Fast on all claims asserted against her. Thankfully, she was vindicated. As you can imagine, this was a very emotionally charged trial experience for Dr. Fast. She's an internist. She practices medicine in Wayne County. She's been treating and providing care for patients in Wayne County for many years, and she is being accused of engaging in fraud. So the trial is very emotionally charged. Thankfully, the jury came back in our favor, and she was vindicated of these very serious allegations. After the trial, the appellant was dissatisfied with the verdict, so they went ahead, they filed post-trial motions, which were denied, then they filed this appeal. All right, this is nothing more than trying to get a second bite of the apple, another day in court, at the expense of taxpayer dollars. That's why less than 1% of cases, civil cases, are tried. They cost money, not just to the litigants, but to the public. Now I want to step back here and just briefly give the court some context to this trial. So this trial was the culmination of a very lengthy business dispute between the appellant, Mr. Gallagher, and a co-defendant, Mr. Dagley. They go back many years. They engaged in business dealings together that went south. In 2015, Mr. Gallagher, through his attorney, Mr. Halligan, filed a lawsuit in Wayne County against Mr. Dagley and some businesses. In that lawsuit, he obtained a default judgment against Mr. Dagley, and then decided to expand the scope of the lawsuit, and he brought into the lawsuit certain individuals and businesses from Cleveland, Ohio. That lawsuit was then transferred to Gallagher County, and became very messy and very contentious. And in the course of that lawsuit, my client, Dr. Fast, was brought in via an amended complaint as a new defendant by Attorney Halligan. despite the fact that Dr. Fast had absolutely nothing to do with any of these contested business dealings and transactions. She's a doctor. She was not involved in any of this stuff, but nonetheless, she was dragged into this case. And then after she was dragged into the case, Mr. Dagley's attorney filed a motion to disqualify Attorney Halligan based on a conflict. The Cuyahoga County judge granted that motion and disqualified Attorney Halligan in the Cuyahoga County case. Shortly thereafter, Mr. Gallagher decided to dismiss his claims and dismiss that action, and then within 2 months of dismissing the Gallagher County case, he went ahead and he filed, Attorney Halligan now, kind of end round of the disqualification, filed a lawsuit, this lawsuit in Wayne County.
Now,
Yes.
no offense, but how is this relevant to whether jury instructions were adequate?
Fair enough, Your Honor, so just want to give you some
And I
background.
just don't know if this is in the record either.
I believe it's in the record, Your Honor, but that's a fair point. So let me just focus now on the jury trial and get you kind of focused on what happened at that trial. So first of all, jury instructions. Okay, jury instructions. The standard is abuse of discretion. The trial court, in order to reverse on jury instructions, it's an abuse of discretion standard. The trial court properly instructed the jury on the claim. The trial court instructed the jury on the elements of the claims in the case. And so the jury instructions in this case were properly given by the judge.
Were the badges of fraud that they wanted to have as a jury instruction not relevant to this claim?
The badges of fraud, so the fraudulent conveyance claim, there's 2 elements to that claim. One is, let me just read it for the court so I get the language right, I have it here. Need to show that the person did not receive a reasonably equivalent value in exchange for the transfer or obligation. So that's one element. Okay, we established in the trial they could not satisfy the element because Dr. Fast, and we did this by showing bank records and credit card statements, Dr. Fast paid out more than she ever received. So they could not establish that element. The second element is intent. That's where the badges of fraud comes in. So Judge Weiss, the trial court judge, had the discretion based on hearing all the evidence whether or not to include those badges of fraud. He decided not to include the badges of fraud in the instruction because we established there was no, they could not satisfy that first element of their fraudulent conveyance claim. So then we had jury questions, and that's the other part of this appeal, is that there were jury questions that came during the course of the deliberations. And Judge Weiss, trial court judge, handled those questions very appropriately. The questions came to the judge then gathered counsel together, read the question to counsel, everyone had the opportunity to weigh in on the question, give their input on the question, and then the judge went ahead and then responded to the questions with the jury. That's how those questions were handled. That's how you handle those questions in trials.
So all that's on the record then?
It is, I'm not sure how much of the actual deliberations with counsel are in the record, Your Honor. I know at one point he went on the record, but there was multiple questions, and some of that was just, I think, with counsel. And decisions were made jointly with the judge and counsel, weighing in and giving input. So this was a collective effort here in terms of responding to questions. And we'll note, by the way, that when you get questions from a jury in a civil trial, it can be very telling. And I think it was quite clear after receiving the first question, the jury did not want to find against Dr. Fast. And they didn't. So that's how the good questions were handled.
The plaintiff indicates that they filed affidavits explaining the process of what happened with those questions. And you did not dispute that process was, as they described it in their affidavits. Is that fair for us to say there's no dispute, or are you disputing what they say happened on the record for those questions?
We did not respond to the affidavits. I'm disputing what they're saying in terms of what happened. I go by the record, Your Honor. The record is the record. And
If I understand what you're telling me, at least that's this, there is no record. The judge didn't bring a court reporter in, didn't put any evidence on. It just happened, I don't want to say informally, but brought everyone in, talked about here's what the questions are, here's what we're going to do, what do you folks think, and then made decisions based upon that. But none of that recorded on the record that I can look at.
that's correct, Your Honor. Yes. That was not on the record. So that's how the judge handled those questions. And I think it's important to note that it was a collective process, Your Honor. He did hear from everyone on those questions, and then
Well, we really don't know though, do we?
decisions were made. Well, That's correct, Your Honor, it's not in the record. I was questioned, right?
And you didn't file a completing affidavit to what they filed when you did your J&OB, I take it?
We did not file a competing affidavit to their affidavits. But I come back to the fact, Your Honor, that the judge here, in my opinion, ran a very fair trial. He allowed the plaintiffs to put on their case without restriction, without impediment. My client was subject to many hours of cross-examination on day one. That actually went into day two. Both attorneys cross-examined my client at trial. They even were able to cross-examine Mr. Dagley, who at the time was incarcerated at Richfield. He testified live via Zoom, so they had the opportunity to cross-examine Mr. Dagley during the course of the trial as well. So they were able to put on their entire case to the jury. They were not impeded or restricted in that way. I think it's important to note that there's no evidentiary issue on appeal for this court because the trial court judge allowed them carte blanche, quite frankly, to put on their case without impeding their ability to put on evidence. So they had the opportunity in Wayne County to put on a case before a jury, which is what they did, full 2 days of trial. The jury heard all the evidence and came back and concluded that my client, Dr. Fast, was not responsible for anything, was not liable, and defense verdicts came down in her favor. So,
I think, counsel, however, with respect to especially the post-trial motion, the judge seemed to say, in the face of a motion that says this verdict should not stand because of all of these errors, the judge said you had your trial. Is that responsive to what the argument was in the post-judgment motions, that you had a trial? I mean, it presupposes that you had a trial if it's a post-judgment motion.
well, part of the post-judgment motion, I believe, was they took issue with the fact that the judge did not grant a motion for directed verdict. And so I think the judge was addressing that point for sure, that listen, I listened to the evidence, I decided that this case needed to go to a jury. I'm not going to grant a motion for directed verdict. We moved for a directed verdict as well, and that also was denied. I think the court, after hearing the evidence, decided, I'm going to allow this case to go to the jury for deliberation and verdict. So I think the court was addressing that point for sure. And then in terms of the jury questions, the jury instructions, again, it's an abuse of discretion standard on jury instructions, and the judge did not abuse discretion here.
Well, if it's a matter of law, it's not an abuse of discretion. If the evidence demonstrates that they should be charged on something, the abuse of discretion comes in, doesn't it, when it comes to how they should be charged and then the manner in which it's done, not necessarily whether they're entitled to an instruction on a legal issue.
So the abuse of discretion is so long that the judge decides the law that is to be given to the jury, and based on the evidence that is adduced during the trial, that's correct. And the judge made decisions based on the evidence he heard sitting there for 2 full days of trial. And he had the discretion to then instruct the jury based on what he heard. That's right.
Thank you. I'm going to go back to Judge Hensel's question in regard to the journal entry that overruled the motion for the J&OB and the new trial. It doesn't really have any legal reasoning, right? It sounds like more just like, hey, everybody heard the evidence, you're done.
Well, I think, again, I think, Your Honor, it comes back to, I think that's true. And the court, again, listening to the evidence for 2 days on a judgment notwithstanding the verdict, made the decision that all the evidence came in, the jury was able to take in all the evidence, the court had the discretion to instruct the jury, which it did, and the jury came back with its verdict.
And then,
So I think, to your, real fast here, I think the point there is just, I think the trial court judge really just relied on the fact that he sat there for 2 days, he listened to all the evidence, and then made decisions based on the evidence that was adduced.
Certainly understand that.
Yeah.
Were there some component of the J&OB and motion for new trial that didn't deal with here's what the evidence said, but dealt with here's where legal mistakes were made in this trial? Did the J&OB in its motion, did it include some arguments of here's where legal mistakes were made?
I think they just center around the evidence and then I think the instructions, Your Honor. Yeah, which again comes back to the discretion.
But the judgment entry says things like defendants are uncollectible, fast is collectible. Plaintiffs don't want to do it all over again. Plaintiffs chose to invest the money with their eyes wide open. It's just kind of some additional dialogue in the judgment entry when ruling on both a motion for new trial and a motion for judgment notwithstanding the verdict. Is that because the actual motions did not argue the correct points about what we would see, or is that some surplus that just appears there for some reason?
I think, Your Honor, it may be a combination of the two. I understand the point, Your Honors. All I can tell you is that the trial court listened to the evidence, and that was the response to motions that were filed post-trial saying, we want to do it again. We want another bite of the apple, and so that's how I responded to it, Your Honor. That's all I can say about it.
Thank you. You have about 9 seconds.
No, unless there's any further questions from the panel, I've concluded my argument. Thank you very much. I really appreciate it.
Thank you.
Yes.
I'm going to try to blitz through quite a few things I wrote down, probably too many, so if I'm speaking too quickly.
Before you start that blitz on these motions and this language that's in there, you know, whether I agree with it or not, there's some law that says if you make a directed verdict motion and you give specific reasons, you are confined to those reasons, and anything else out there you're not allowed to talk about. Is this language part of what was argued on both the first motion and the second motion and the motion for retrial? Does the question even make sense?
You mean is J&OB entry?
Yes.
No, it's not. It's completely out of left field. I think, as I recall, it's been about a year. Our J&OB centered around the jury instruction problem. That was not a collaborative thing. That was, we're off the record in the courtroom. All the attorneys are present, parties are present, talking about this question. Over our objection, we said the answer is no, we don't have any authority because it's after hours. None of us brought anything addressing that authority. They say yes because it's obvious where the jury's kind of going. And the judge says, I'm going to tell them yes. Okay, now the jury's verdict itself says it's problematic in light of the inter-corporate conspiracy doctrine. It's just impossible. It's a legal problem there. It indicates that there's a problem with the instruction.
Okay, thank you.
Yeah, more on that though. Yeah, it does not address the issue with the jury instructions.
And one question before you get into what you want to say about, so I understand, I cannot determine from the record, your original jury instructions you filed. Are they part of the record? You proposed them, went to the judge, but aren't part of the record before on the court, like on the document?
If they are in an exhibit stack somewhere, I don't know that. He instructed us to bring them to the court, I believe by lunchtime, or by the end of the first day of trial.
Okay.
We did so because I realized we had not filed them. I attached them to one of the affidavits. I believe it was my second affidavit.
On the J&OB, to the extent they're in the record, it would be attachments to your J&OB.
Correct. And again, it was a run challenge, because that's exactly what I distributed to everybody. Okay. Just to get back to the big picture, it's very important to stress this. I think the first 3 checks, and this goes back to the end of 2015, they were all to Dagley from a business client of SLB, and he endorsed them over to FAST. That was a fraudulent transfer, so we got it, no question. And then she changed the name of she, not he, the owner of SLB, changed the name to BDP, and in her terms assumed, or in her words, assumed ownership of it. Now, again, even in his oral argument, he's focusing only on the constructive fraud portion of the statute. 133604A2 is what he's talking about. A1 says with actual intent to hinder, delay, or defraud any creditor of the debtor. You can only speak to actual intent by the badges. That's why they exist. That's why they're in the statute. And if you read through those, I think cited case law that only 3 of them have to be present, and we've got maybe 8 of them. I mean, they're almost all present. So that's why that's important, sorry. Yeah, at the end of the day, we have cooperation between these lovers, Fast and Dagley, and what was the upshot? It's what this is intended to prevent, concealing of his revenue, because she had nothing to do with BDP's operation. She testified to that. She knew nothing about it. He's sitting, making phone calls, taking clients on trips, going to the Florida Keys, living like, high on the hog, and somehow coming up with money to pay off these IOUs, even though she as owner of BDP is not paying him a salary or giving him a 1099 or contracting anything. And the upshot of that is she harmed Gallagher, the creditor of Dagley. Just a couple other things. Maybe, I mean, I can only speculate why he wrote what he wrote, the judge wrote what he wrote in his, the JE addressing the JNOB. I mean, Attorney for Fast says that things were fair and so forth. I mean, there's evidence in there that we were rushed. He was pushing us through testimony, hurry up with witnesses, and he didn't allow us to introduce, a PNC representative brought a box of checks. And I asked, well, do you want us to get her in now to validate these? And he said, no, you guys are going to stipulate. And maybe that affected the verdict too, I don't know, or at least the amount of the verdict.
And counsel, can you just give us a conclusory statement as you are over?
I think the short version is the collective action of these two definitely harmed Gallagher. That's the purpose of the statute. That's the purpose of a conspiracy claim. And because of the instructions, the problematic instructions, in particular, the lack of punitive damage instruction, he didn't get a fair shot because the jury wasn't correctly instructed on the law, and the law would have informed Fast's culpability.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be sent to all parties to this appeal by the clerk of courts on the day it is issued. You may also check the Ohio Supreme Court website as our decisions are posted there. Thanks again.
Thank you very much.
Appreciate it.